So if you've spoken to me about case resolution and litigation, you've probably heard me refer to something called Motions Day. I thought I'd take this opportunity to explain a little bit about what Motions Day is and how we use it to get our clients the compensation they deserve. In cases, typically in conceded cases, the government will make a proffer, or they will tell us what they think your case is worth. And if we disagree and we can't come to an agreement on that, we tell the court that we've reached an impasse on the value of your pain and suffering mostly. Those types of cases are typically ones that are selected for Motions Day, where the issues are very narrow. We may be only talking about what the value of your pain and suffering is, and that's the only dispute in the case. Entitlement has been decided in your favor. We may even agree on the amount of out-of-pocket expenses that you need to be reimbursed for. So it's simply a matter of determining what's your pain and suffering worth. So if the court decides they want to do a Motions Day, they will inform both parties that there's an opportunity for Motions Day, make sure both parties are available, and then set the case for a hearing. We just participated in one recently, September of 2025, for a client of ours. And what we do is I travel to Washington. There's a hearing room at the Office of the Special Masters down the block from the White House. I usually will get there a day before, spend enough time preparing for the hearing, making sure I know all the ins and outs of the case. Before we even get to the hearing, the court will, of course, know what the issues are. In this case, we had already filed a motion, and I outlined for the court exactly what we were looking for in pain and suffering, and supported that with review of the evidence, citations to other cases that I felt were similar to this client's experience. So the court already has a general idea of what my position is on the case. And they'll know what the government's position is on the case as well, because the government had filed a response with their own arguments and their own case comparisons. So walking into that hearing, the Chief Special Master already knows exactly what the issues are. They know what our positions are, but they want to hear from us too. So we'll spend typically no more than 15 minutes each arguing in support of our client and in support of our motion. So this past month, stood before Chief Special Master Corcoran. I argued in support of our client to gain much more compensation than what the government was proposing. In this case, we were about $55,000 apart in pain and suffering. I'm happy to say that Chief Special Master Corcoran saw the case a lot more like I did and awarded an amount that was much closer to what I proposed than what the government proposed. And he issues that decision straight from the bench. It's typically a faster way to getting a decision than waiting for the court to issue a written decision without a hearing. So yeah, that's the gist of Motions Day. Part of the reason I wanted to talk about it was to sort of dispel any sort of fear or concern about litigation. We are litigation attorneys here. This is what we do. This is why you get an attorney, to help you with your vaccine injury case. By now we've gained a lot of experience, standing before the judge and arguing on behalf of our clients. We know what these cases are worth, and proof is in the decisions that we get from the Chief Special Master.